Bristows, and thank you for taking the time to attend our Commercial IP update seminar. Delighted to see so many of you along this fine December morning. I'm Matthew Warren, and I head up the Commercial IP group at Bristows. And this is the second of our annual update seminars, the first being pretty successful. What we aim to cover new developments in case law and legislation that has occurred over the last year or so, and we try and pick out the more interesting aspects of the stuff that would have more of a commercial impact on what we do. And it's fair to say we take quite a broad brush approach to this. So where there are cases that are on specific points of contract law that may not necessarily have intellectual property as their subject matter, but would nevertheless impact intellectual property agreements, we include those as well. And in fact, I think one of the first speakers is going to be talking about a case to do with real property, just because of the impact it has on the way that contracts are interpreted. So we have a star-studded lineup this morning. Kicking off, we have Nicola Russell, who's posing the question, will a judge fix my less than perfect contract drafting? So there've been a couple of cases where a judge has looked at contracts and which have had various issues with the drafting and reached different conclusions about how to deal with those issues. Then next up is Laura Anderson, who is going to look at how the courts interpreted contracts in recent copyright cases. Then we have Fiona Nicholson, who's going to look at that perennial question of contracts being such a nuisance in that you tend to find they exist when you don't want them. When you do want a contract, you find it's not been validly entered into. So Fiona's going to look at those aspects and cases connected with that. Then Sahar Shepherd poses the question, does my contract deal properly with affiliates? And as you probably know, in contracts, affiliates are dealt with in various different ways. And Sahar's going to look at how the ways in which you deal with affiliates affects, in particular, intellectual property rights and how they're dealt with in contracts. And then finally, we've got Osman Zafar, who actually is from our competition law group and volunteered, or that's probably too strong, agreed to come and talk to us about the new technology transfer block exemption, and which is now finalised, and he's going to go through some of the key changes made to the new block exemption. Then we'll end up with questions and answers at the end of the sessions. Because we've got quite a lot to get through, I think it would be better if you could keep your questions to the end of the session and perhaps make a note of them so we can deal with them all at the end. And then we'll finish up for tea and coffee, which I think is going to be about 10:45. A couple of matters of admin. Firstly, if you could switch your mobile phones to silent. I said that. I should do so. We have some feedback forms, and we'd be very grateful if you could complete those and include any suggestions for how we might improve the session, the format, or ideas for what subjects we should cover. And I think this is also covered by continuing education points. So if you collect those continuing CPE points, please let us know at the end, and we can make sure there's a form there for you to fill in to claim those back. So without further ado, if we could start with our first speaker, which is Nicola Russell.
Morning. See my slides rather than you. So my name's, as Matthew said, my name's Nicola Russell. And today I'm asking, will the court save you from defective drafting? I'm going to run through two fairly recent cases. The first is Network Rail Infrastructure and Fremont, which was a High Court decision from 2013. And the second is Profit and Huggett, which went to the Court of Appeal in 2014. We don't have much time, but we'll quickly run through the facts of the case. Probably best to have a look at the photograph there, which we got from Google Maps, because the facts, as they were written, were actually quite confusing because of some of the terminology that was used. So the big outlined square red bit was referred to as a platform, but in fact it's actually a bridge of shops over a railway line. And above the platform is a road. That's a road bridge. And in between the road bridge and the main body of the platform where the shops are, that bit of land was called an infill, and it was actually filled in so that there wasn't a drop down onto the railway line below. So that's kind of the key. If you keep that picture in mind, that's quite key. And the issue that the court had to decide was whether or not whether the infill was demised under the lease for the whole of the platform, or whether what was actually demised was just the main body of the platform, so the bit where the shops are, because the infill needed some substantial repair work, and the tenant didn't want to pay for it if it wasn't demised under the lease. That's good. Oh, there you go. It's clever. Okay, so the key facts. There was a lease granted in 1964, and the premises demised under that lease included the platform and the infill. In 1984, the road bridge bit was widened to cover over the infill section, so the infill was no longer visible. And the 1990 lease stated that the land was of a platform or raft, as the same are delineated in the plan. And the plan was taken from an ordnance survey map, and the map was drawn after the road was widened, so the plan itself excluded the infill. The plan that was attached to this 1990 lease was different to the plan that was attached to the 1964 lease. Obviously, because the plan in the 1964 lease clearly showed that the infill was included, whereas the one attached to the 1990 lease, this ordnance survey map, showed that it followed the contours of the new road. In 1999, the claimant, so Network Rail, granted a lease to the tenant, Fremount, and the premises defined in that lease was those being granted under the 1990 lease. And as I said, the infill needs substantial repair, and the parties dispute whether the infill is included in the lease. So what were the arguments that were put forward? Well, Network Rail argued that there was clearly a mistake in the 1990 lease because it excluded the infill. And the infill was physically and functionally part of the platform and therefore logically included in the land. Now, the infill actually attached to the platform as opposed to the road. So they were arguing because of that, any reasonable leasee who would have inspected the property prior to entering into the lease would clearly have seen that the infill attached to the platform and therefore should have realised that it was being demised under the lease. The language in the 1964 and the 1990 leases makes it clear that the whole platform, including the infill, was demised, and that this must prevail over the plan if there was inconsistency. So the claimant was arguing that the written words should have prevailed over the plan because of the inconsistency. Go back. How do I go back? There we go, sorry. Okay. The defendant argued that the land demised in the 1990 lease was that demised in the 1990 lease, and that's the actual wording that was used in the lease, and that the land demised under the 1990 lease was described in the plan, so that's the ordnance survey plan, which clearly excluded the infill. And the defendant argued that even if the 1964 lease included the infill, the extent of demise may have been altered during the 1990 lease negotiations. And the court found actually that could well have been possible because the infill area is now part of the highway. So it could quite well have been possible that during negotiations it was decided that the infill should be excluded. But evidence of this was inadmissible in this trial because it was a trial for rectification by construction, which I'll come on to in a minute. If the infill was to be included in the 1990 lease, there would have been express reference to this. And So the defendant was arguing that because of this new highway that was being built, if the intention was that the info was going to be included in the lease, then there would have had to be reference to it because something had changed since the previous lease. So the case, the judge ran through the key principles on construction. The starting point in the construction process is the language of the contract. If the language is clear, it can't be departed from, even if the result seems to be unreasonable. There's an exception. This is called the Fifth Investors Compensation Scheme principle. And the judge said that in the very rare cases that the court is convinced that the parties made a mistake in the contract and it's possible to see what the parties really intended, then in such case only the parties can apply for rectification by construction without the need for a full-blown claim for rectification. So in such cases only the courts may be able to apply rectification by construction. If, however, the language is capable of more than one interpretation, the court may prefer the more realistic or commercial one, even if less consistent with the language. So what did the court decide? The court held that in construing the 1990 lease, the 1964 lease was relevant background material known to both parties because the 1990 lease referred to the 1964 lease. So when entering into the 1990 lease, the parties would have been aware of the 1964 lease. And the judge concluded that on proper construction, the 1964 lease included both the main plot, so the property demise included both the main platform and the infill. The judge questioned what a reasonable observer applying knowledge reasonably available to both parties to the 1990 lease would determine, and the judge thought that such reasonable person would conclude the plan described an area which excluded the infill. And the key factors for making that decision were that the road widening was publicly available information, the nature and extent of the underlying structure was reasonably available to the tenant of the 1990 lease. The area defined by the 1990 lease plan clearly differed from that defined by the 1964 lease plan. The plans were clearly two different things, so prima facie, clearly something different was intended. And it's clear from the 1990 plan that the land did not include widen highway and the infill underneath. It was clear from the ordnance, that's the ordnance survey plan, which followed the contours of the road. The court found that there may have been a sensible commercial reason for altering the extent of the demise in the 1990 lease, but the evidence of any negotiations were not admissible. And although mistake was possible in the 1990 lease, i.e. that the ordnance survey map was used by mistake without the actual intention to change the area demised, the judge found that this did not just justify disregarding the language and plan, which were clear and consistent with each other and not obviously irrational or mistaken. And so the court was not satisfied that there was a mistake in the 1990 lease, and therefore corrective interpretation was not appropriate. It found that the info was not part of the land demised by the 1990 and the 1999 leases. So what can we learn from this? All the obiter comments were actually quite helpful. For corrective interpretation, the court must be satisfied that there's a clear mistake in the agreement. And what qualifies as a clear mistake? Well, if the words would be ineffective in law or irrational and arbitrary, then that was found to be evidence in itself that something must have gone wrong. And it's also possible to qualify it in other ways. So if there's inconsistency with other provisions in the agreement, then that's evidence that something must have gone wrong. There was no explicit discussion of the standard of proof required to justify corrective interpretation, but it seems clear that the usual standard of proof is not applicable. It's not enough for the court to conclude that it's more likely than not that there was a mistake, particularly as evidence of the negotiations which would prove whether or not it was right were inadmissible. But what is clear is the court must be sure that there was a mistake. It's insufficient to conclude that a mistake was more likely than not. Moving on to the second case, this is Huggett and Profit plc. So Profit is a software developer. Profit developed two applications, PR2 and PR3, for the business supplying fresh products. PR2 and PR3 are integrated software applications covering many functions, different functions. Mr. Huggett was a sales manager at Profit, and Mr. Huggett resigned to join K3, a competitor software developer for the fresh produce sector. And Profit sought to enforce a restrictive covenant to stop Mr. Huggett from working for K3 for 12 months. So the issue before the judge here was the interpretation of the restrictive covenant in Huggett's employment contract. He asked whether it was reasonably necessary to protect Profit's commercial interests and whether it was appropriate to protect Profit's interests by the imposition of an injunction. This is the restrictive covenant. It's summarised. It was a lot more wordy than this, but this is kind of the key words taken from it. The employee shall not, during the continuance of this agreement or for a period of 12 months from the determination thereof, carry on or be engaged, concerned or interested in any business which is similar to or competes with any business of the company within the United Kingdom, provided, this is the proviso, the second section, that this restriction shall only operate to prevent the employee from being so engaged, employed, concerned or interested in any area and in connection with any products in or on which he/she was involved whilst employed hereunder. So Profit argued from the literal interpretation of the restrictive covenant, so the literal interpretation of the words any products in or on, this bit, which he/she was involved whilst employed, rendered the covenant pointless because the only products Mr. Huggett was involved with were PR2 and PR3, which only Profit provides. And so therefore it gives no protection to Profit and could not have reflected the true intention of the parties. And Profit argued that any products with which he, Mr. Huggett, was involved did not mean PR2 and PR3, but rather business process software designed for the fresh produce industry, so obviously much broader. At the High Court, the judge decided that on a literal interpretation, any products, if any products meant PR2 and PR3, then it did render the covenant pointless. And so something had gone wrong in the drafting, and the proviso did not give effect to what the parties intended. The court asked what a reasonable person would have understood the parties to mean by their chosen language, and concluded that the minimum change necessary to make the covenant make commercial sense was to add the words or similar thereto at the end of it. The court decided that the covenant was reasonably necessary to protect Profit's trade secrets, and that it was enforceable with that additional wording included in it, and an injunction was appropriate. So Mr. Huggett appealed and argued that the judge wrongly wrote in the additional words to give the proviso wider effect. It was argued for him that it was not open for the judge to find that something had gone wrong with the drafting, and that the clause was formal and lawyer-drawn, and that the words were carefully chosen, in particular because it was an employment contract in which the parties take extra care, arguably, to make sure the words chosen reflect their intentions. And so a court should be very cautious before finding and correcting supposed mistakes. He argued that widening the language would give Profit greater protection than reasonably necessary because it prevented him from working for a competitor in connection with products which he had no prior involvement. And so from a public policy perspective, that was wrong. The Court of Appeal overturned the High Court judge's decision. Although in principle there was agreement between the courts that when a contractual clause is ambiguous in meaning, the court should apply an interpretation that secured a commercially sensible solution rather than an absurd one. But the Court of Appeal did not agree that the covenant was in fact absurd in the way that it was originally drafted. It decided that any products refers only to those products with which Mr. Huggett was involved while employed at Profit, so i.e. PR2 and PR3. it said although the proviso was absurd because no other competitor provides those products, in reality what it does do is it prevents Mr. Huggett from setting up his own business selling those products only. So although it agreed that the covenant had little or no commercial effect, it held that it was clear and it was carefully drawn legal prose where the words had been chosen deliberately and carefully, and the drafter knew that it was necessary to draft it tightly to ensure that it was enforceable. And so something hadn't gone wrong with the drafting, the Court of Appeal found, but what had gone wrong was that the draftsman did not consider how the restriction would achieve any practical benefit to profit. Despite that, it wasn't for the judge to remake the parties' bargain, and profit had made its bed and now must lie upon it. Mr. Huggett's proposed activities with K3, which does not provide PR2 or PR3 products, didn't therefore not breach the terms of the covenant, and the appeal allowed and the injunction discharged. So in conclusion, what can we find from that case? Well, in general, a court will try to give sensible commercial interpretation to the provisions of the agreement, that's clear. And where there is a manifest error in the drafting, it may imply wording to remedy the error. But something we've been questioning is whether a court may actually be less likely to find that there's been a manifest error in a provision that it doesn't like from the outset. So, for example, something like a restrictive covenant or an exclusion of liability, which from public policy perspectives courts generally don't like, because it seems to us that there did seem clearly to have been something that had gone wrong with the drafting of that provision, and yet the court still found that there wasn't anything wrong and that it wasn't going to imply wording into it, perhaps because the court didn't want to enforce it against Mr. Huggett from a public policy perspective. So question whether a judge's tendency to find mistake will turn on the sort of provision that they're looking at. I'll leave that there. Thank you very much.
Great, thanks, Nicola. Hello, everyone. I'm Laura Anderson, and I'm going to be speaking now about a couple of copyright cases which were sort of reported earlier this year, both of these two cases. And neither of these cases are creating new, fantastic, groundbreaking new law, but they're both helpful reminders of some of the pitfalls that can arise in the context of commissioning creative works. So the first case is B4U Network and the Performing Rights Society. And this case really, at the heart of it, there are two copyright assignments which were conflicting, and the courts were given the task of trying to determine which should prevail in the event of this conflict. The facts of the case were such that Salim and Suleiman Merchant are composers of Bollywood film music, and in 2004 each of them entered into a written agreement with the Performing Rights Society, under which they agreed to transfer their rights in copyright to the PRS, really to act as their collecting society. The wording of the assignment, which I put up here on the slide, was important, and the court spent a bit of time analysing this. And effectively they agreed to assign their existing copyright, but also there was an agreement of future copyright, which I think, as we all know, is permissible as a matter of law. So the wording was such that the assignment, each of them assigned absolutely for all parts of the world the rights which belong to you on the date of this agreement, or which you may acquire or own whilst you remain our member. And it's that second bit which is underlined, which is obviously the assignment of future copyright. So in 2008, the composers then went on to enter into another agreement under which they were commissioned by a film producer to write music for a specific film, and they entered into a commissioning agreement completely separate from this arrangement that had been entered into in 2004 with the PRS. And under the commissioning agreement, the composers agreed that the film producer would own the copyright in the commissioned work upon its creation. And the wording of that commissioning agreement was quite clear that as soon as the copyright work was produced, the copyright in the film music would vest automatically in the producer of the film. And then what subsequently happened is that B4U Network, I'm not sure if it should be pronounced Before You Network, but I'm sticking to B4U as an old-fashioned legal type. So B4U acquired the rights to the music from the producer under a license and then went on to broadcast the music. And then at that point up popped the PRS, which said, oh, hang on a minute, we're the proprietor of copyright in this music, we haven't granted a license, you have no interest, and therefore you are an infringer. So the PRS brought these infringement proceedings and won at first instance. And you can see here the conflict or the tension, because on the one hand you think, okay, well, if you've got someone who produces a copyright work, A, who then assigns to B, and then subsequently purports to assign to C, it really doesn't feel right that B should be defeated. Why should C get anything if it's already been assigned to B? But on the other hand, you think, okay, well, hang on a minute, if C paid for the work, and it would never have existed but for the fact that C commissioned it and paid for it, is it really right that B ends up as the proprietor of the copyright and C is left with nothing? And so that's the dilemma that gave rise to this action. And as a result of having lost at first instance, B4U then took the case to the Court of Appeal. So B4U argued that as copyright had vested immediately in the producer under the commissioning agreement, the copyright was never actually owned by the composers, and so the rights weren't covered by the 2004 assignment to the PRS. So if we look back at the wording which is underlined in the assignment, they said, you know, it covers future copyright which you may acquire or own whilst you remain our member. And they said, oh, one of the composers, they never acquired it or owned it because under the commissioning agreement it went straight to the commissioner, to the film producer. So that was really the heart of the argument. They also argued that the assessment of ownership has to be made at the time that the work was created. However, the Court of Appeal disagreed, dismissed the appeal, and found that the PRS was in fact the owner of the copyright, and therefore B4U was an infringer. So the analysis is quite interesting because the court took a bit of time to look at the whole concept behind the provisions in the CDPA which relate to assignment of future copyright, and there's a little bit of history which was interesting. But just to summarise the thought process that the Court of Appeal went through, as we all know, under Section 11 of the Copyright Designs and Patents Act, the author of a musical work is the first owner of that copyright, subject to certain statutory exceptions, for example, where you're an employee who develops a work during the course of employment. So in these circumstances, the merchants, the composers, they were the first owner. And we also know under Section 90 that copyright may be assigned, which is obviously what happened here. Under Section 93, for an assignment to be effective, it must be in writing, signed by or on behalf of the assignor. And here we had two assignments, both of which were in fact in writing, signed by or on behalf of the assignor. It's a well-established principle as a matter of English law that a present assignment of future property is effective to vest equitable title in the assignee. And that's not just a question of copyright, that's any type of property. It's also a well-established legal principle that legal title to property cannot be transferred until that property exists. So in the context of copyright, you can have a present assignment of future copyright, and that assignment will vest an equitable title in the assignee, but legal title can't pass until the work has actually come into existence, which kind of makes sense. Section 91 of the Copyright Designs and Patents Act sort of enshrines in statute this principle as far as copyright is concerned about the ability to have a present assignment of future copyright. And Section 91 provides that where there's an assignment of future copyright, the copyright vests in the assignee or his or her successor as soon as the copyright comes into existence. And that happens as a matter of statute. So legal and equitable title pass and vest in the assignee without the need for any further documentation or any further assignment. And that didn't used to be the case before the CDPA was enacted. When we were just talking of principles of common law and equity, then you needed to have a separate assignment of legal title in order for legal title to transfer once the copyright work had actually been produced. And that created some unfairness in that you might have acquired equitable title, not perfected it, and then found that there was some reason that you couldn't take the benefit of that equitable title. And Section 91 effectively prevents that happening because the title vests automatically, you don't need to have any form of confirmatory assignment, and the copyright doesn't pass through the assignor, it just arrives automatically in the life of the assignee. Section 91 has a few requirements in order for it to be effective. There needs to be an agreement in writing. I think it's quite interesting that the statute uses the word agreement rather than instrument, which suggests that there needs to be some form of consideration involved. So an agreement in writing signed by or on behalf of the prospective owner, so whoever's going to create the copyright work, and the assignee needs to be entitled, as against all other persons, to require the copyright to be vested in him. So they have to really have the right to enforce that. There's no one else who's got a prior conflicting interest. So it's also a well-established rule of equity that a first equitable assignee will take priority over a later purported equitable assignment. So the Court of Appeal excuse me, were really quite clear that they were saying, well, look, we've got these two assignments. The first assignment is a correct and valid assignment under Section 91, and therefore as soon as the copyright work came into existence, legal and equitable title would have vested in the PRS, and effectively there was nothing left to assign to the film producer under the 2008 commissioning agreement. So the only real question that the Court of Appeal said existed was whether the assignment as drafted in the 2004 PRS contract was broad enough to cover the particular work in question. And they found that it was. They said that the wording of the assignment, which referred to rights which you may acquire or own, basically covered a category of rights capable of being owned. And the argument that was put forward by B4U, they didn't really have any truck with that argument. The fact that it somehow gone straight to the commissioner of the subsequent work, the film producer, they're saying it didn't matter that the composers never really owned the rights. The wording of that 2004 assignment was clear. Under Section 91 it was effective, and therefore that assignment prevailed. So I suppose the take-home messages are that you can't get confused into thinking that there's some sort of principle of bona fide purchaser for value in the context of a copyright assignment where it's an assignment of future copyright, that the statutory provision really obviates that sort of analysis, and the statutory provision is there designed to ensure that if you take an assignment of future copyright, you can enforce that against someone who subsequently acquires a conflicting interest, provided you have those rights and they're clearly intended that's what you would be able to gain from that assignment. So even if a commissioner knows nothing of the earlier assignment and has paid for the work, that is irrelevant. So I suppose for our day-to-day lives, that means that where you are commissioning a third party to produce a copyright work, whether it's a creative work or a piece of software, the importance of doing some due diligence, understanding the scope of any pre-existing assignments that may be broad enough to cover copyright works of this nature, particularly the sort of umbrella assignment that was included in the PRS agreement, and obviously the importance of diligence together with warranties regarding title and indemnities in the event of infringement.
So why was there no implied licence in that case then to give commercial effect to the agreement that the other company had paid for?
Well, because the implied licence would have had to come from the proprietor, from the PRS, and they were not a party to that arrangement. The PRS would be willing to grant licences because that's its job. The PRS, the whole reason why it exists is to grant licences to third parties in return for a licence fee. So the PRS would be saying, well, we're more than happy to grant a licence, give us a bell and pay for it. But it wouldn't be in the gift of the composers to grant a license, not the composer, sorry, the producer to grant a license because they had no interest. And as far as B4U is concerned, if you're exploiting excuse me, a copyright work but you don't have a license from the proprietor, then you have no license, so you're an infringer. It's a jungle out there. The next case is looking at implied licenses, or the scope of licenses, what can be implied when your terms aren't clearly set out. So echoing some of the points that Nicola was making previously, kind of how the courts approach contractual interpretation. So this case is Orvec International and Linfoot's, and Orvec trades in textile products of the airline industry, so pillowcases, those blankets that never keep you warm, little headdrests at the back of the seat that make you worried that someone's greasy head has already lived there. So all those lovely products, some of which Orvec produced which were completely generic, and some were branded with the livery of different airlines to whom it supplied these products. And between 2002 and 2011, Orvec engaged Linfoot's, which was an advertising agency. And Linfoot's was tasked with taking photographs of Orvec's products, and the products were then featured on Orvec's website and also in promotional materials that it produced. And here's a little picture of a pillow, which is, you can't really see, but it's got a tiny little British Airways logo in the top right-hand corner. And this pillow was described in the case as the British Airways pillowcase. So there was quite a lot of detail about specific photographs that were taken by Linfoot's in the context of their work for Orvec. The work was all contracted under Linfoot's standard terms, which were pretty slender to say the least, but one of the terms was very clear that Linfoot's retained ownership of copyright in the photographs, and this was not disputed by Linfoot's. Orvec and Linfoot's then parted company in 2011, and it was agreed that Orvec could continue to use the photographs for its own internal use and also for the supply of materials to its customers. Linfoot's then started working for one of Orvec's suppliers, Intex, and Intex had in fact manufactured some of these products which had then been supplied by Linfoot's, and so the photographs of these products, some of these same products had actually been manufactured by Intex, and so these photographs were useful to Intex, and Linfoot supplied them to Intex, and some of the same photos then appeared on Intex's website. And Orvec was obviously annoyed about this. It had paid Linfoot to take these photos. It obviously felt that they were very personal and connected to its business because they were photos of its products which it had supplied to its customers. So Linfoot argued that there was an implied term, those old favourites, an implied term in the contract between Orvec and Linfoot, that the license that Orvec had to use the copyright in the photographs, that this license was perpetual, but more importantly, was an exclusive license, on the basis that these photos, as I said, were very personal to its business, or very connected to its business, and certain of the photographs, but not all, included Orvec's trademarks, or the trademarks, livery, or logos of Orvec's customers, and so Orvec argued that Linfoot's should have no legitimate use of those photos for any other purpose. And if that were the case, it would only make sense then that Orvec could use them and an exclusive license should be implied. However, the court found that that wasn't the case, that the license was non-exclusive, and so Linfoot's was not in breach of any implied term, and as a result, Linfoot's was free to supply these photographs to Intex. And the analysis was a helpful reminder of really the process that the court goes through when looking at implied licenses or implied terms generally, but particularly in the context of copyright licenses and commissioned works, when this issue crops up in the courts really every couple of years. The court pointed us to Lord Hoffman's analysis in Attorney General of Belize and Belize Telecom, which is a really good summary of implied terms and really the principles that we should be thinking about in that context. And remind us that when looking at any implied license of copyright or really any intellectual property rights, this will turn very much on the facts and will be assessed on normal contractual principles. And the assessment of whether a term can be implied goes no further than being part of the objective investigation into what a document was intended to mean. So there's no question of what's reasonable, what's fair, what's standard in the industry. All of that is only part of the overall analysis that one might adopt when looking at what the particular document in question was intended to mean on an objective basis. So a proposed implied term needs to spell out what the contract actually means, as I said, on an objective analysis, and a minimalist approach is required when implying anything that isn't there. The more complex the proposed term, the less likely the reasonable person would take it as an implied part of the contract when performing that objective analysis. And you might think, oh, hang on a minute, this sounds a bit similar to the Dr. Martins case that was decided a few years ago back in 2005, where the Court of Appeal found in those circumstances that a designer who had created a copyright work of a logo for Dr. Martins that was the Dr. Martins boot Airwave logo, in those circumstances the Court of Appeal found that in absence of a written contract that there was an equitable assignment of copyright from the designer to Dr. Martins as a trademark proprietor. And that was really quite an unusual decision. The courts are generally very reluctant to imply an equitable assignment if there isn't something in writing. And then the next step down there, it's also harder to get an exclusive license implied. So you could think, oh, well, this case is a bit similar because there are trademarks, Orvex trademarks were included, and that was an argument that they put forward. But the court disagreed with that argument in this case and distinguished the Dr. Martins case on the basis that there's a difference between creating a logo for a client, which really no one else should be able to use without infringing the trademark, and so is very strongly identified with the client's property. So difference between that and the situation which we had here, which was creating a photograph which includes a logo or a trademark. And the court in this case said there may still be legitimate uses for a photograph, for example, if the logo is removed. And that seems a little bit contrived, but I think a lot of that, as with all cases, is determined by the facts and the circumstances. But I suppose if you've got a British Airways pillow, one pillow doesn't look that different from another pillow. But here, actually, we're talking about Orvex trademark. The court wasn't really that bothered about whether the trademarks of the customers of Orvex appeared, particularly in these circumstances where a lot of the clients of Orvex were in fact the same as the clients of Intex. But the idea being that a copyright work, if it's a photograph, you can make changes to it, you can repurpose it, you can do other stuff with it. And the point being that if you've commissioned someone to create a copyright work which could have an independent use, could be used for different things, isn't completely firmly aligned with your own business, then an exclusive license isn't necessary, and if it's not necessary, then the court won't imply it. The court also found that it would be difficult to imply a complex license on the basis that some of the photos included Orvex trademarks, but others didn't, and you couldn't really imply a license which said it was non-exclusive where the photographs didn't include Orvex trademarks, but exclusive in other circumstances. That's too hard on a contractual basis to imply in. So the take-home messages being that obviously when you're commissioning any copyright works from a third party, the importance of clarity as to the license terms you expect for what uses the copyright will be used, and also the extent of any exclusivity in the event that copyright isn't actually going to be assigned. And also just to keep in mind that in the event that the extent of exclusivity or the license terms are not all clearly set out, the courts will generally go for a narrow interpretation and will limit your ability to use that copyright work pretty much to the purposes of the brief. Thank you. And now I hand over to Fiona.
Thanks, Laura. Now we're going to have a short presentation about one particular case in the High Court last year. Once again, not an earth-shattering case, but one that, as Matthew said, is illustrates a perennial issue about when and when you don't have a contract, which affects all of us, no matter doing IP contracts or anything else. So this case centres around a case, Mr. Newbury against Sun Microsystems, that was in the High Court last year. And this case basically held that a settlement offer on certain terms and capable of acceptance will constitute a binding contract on acceptance. All sounds very simple, doesn't it? But as usual, nobody agrees
and that's why you end up in court. So I was trying to find something that was quite a relevant picture. It's not particularly relevant, but it shows that there can be a misunderstanding, and all these cases are built on I think one thing and you think the other, and we're going to have an argument about it in court. So let's remind ourselves about how to form a binding contract. Well, I'm sure I don't want to any of you how to form a binding contract, but as usual, all the questions are usually on the facts of the case. So obviously we need a specific offer capable of acceptance. We need an unqualified consent that corresponds to the term of the offer. We need to have consideration under English law, but I should say not under Scots law, but we're not talking about that today. You have to create intend to create legal relations and have certainty of terms. So complete, not vague, ambiguous. So that's all simple. We'd all agree with that, wouldn't we? And obviously, these days, contracts can be formed very informally, and I think clients that we deal with often forget that. The fact that you could do any number of ways of agreeing on a commercial contract. Orally, exchange of emails, one or the other. So the whole point is, as Matthew said, you might end up with a contract before you know it. So what about this case then? So that in this case, Mr. Newbury thought he was due some contractual commission from Sun Microsystems. And I think the original amount he was claiming was about £1.5 million. And the case was set down for an 8-day trial in the High Court on the 12th of June 2011. And a few days before that, the parties had obviously been communicating. And basically, Sun Microsystems sent a letter offering to settle. And I'll just read out, it's very short, I'll read out what they said. And you can have your own interpretation, what you think about this. So they said, our client is willing to settle the entire proceedings by paying the claimant, Mr. Newbury, within 14 days of accepting this offer, the sum of £600,000 inclusive of interest, by way of electronic transfer into his nominated bank account in full and final settlement of the claim and counterclaim, plus a sum of £180,000 in relation to his legal costs, quite substantial, I think you'd agree. Such settlement to be recorded in a suitably worded contract agreement. This offer is open for acceptance until 5 p.m, after which it will be automatically withdrawn. The parties agreed to extend that time by half an hour, and then Mr. Newbury's lawyer wrote back and said, we thank you for your letter of 3rd June. We instructed that the claimant accepts the terms of your client's offer, being payment of the settlement sum of £600,000 plus £180,000 in relation to his legal costs. We will forward a draft agreement for your approval on Tuesday the 4th of June. So on the face of it, did we or did we not have a contract between these parties? But unfortunately, subsequent to having this exchange of letters, the parties couldn't agree on the terms of a draft exchange order. Basically, the defendant wanted to introduce terms regarding taxation and confidentiality that were not in the original exchange of emails which formed the agreement. So Mr. Newbury, what did he say to the court? Well, clearly he said the binding contract was made on certain terms. Sun Microsystems made an offer to him. He accepted the offer. It was quite clear. And it was agreed, though, that there was to be an agreement, but that was to record what had been agreed between the parties. It wasn't to say we haven't agreed everything, we're still discussing things. It was basically we've agreed the terms, but we will record everything in a suitably worded agreement to reflect what we've agreed between us, because it was all done in such a hurry. And what he said was execution of this agreement between the parties was not a condition of the contract. And basically he said he should be paid. That's it. It was quite clear to him. Sun Microsystems didn't agree. And they basically said that their letter, which I just read out to you, was an offer in principle. They were not intending to be legally bound by that offer if it was accepted. They were prepared to discuss things with Mr. Newbury, but they did not have a concluded agreement and would not have a concluded agreement until they had reached the suitably worded agreement recording what they were going to agree between them in terms of the settlement. So they said the exchange of letters on the 3rd of June was not an agreement. It was an agreement to agree, and there were still further terms to be agreed in writing. And a number of cases were quoted in this case, previous cases, and one of the most relevant ones, I think, is this Air Studios v Lombard case, which makes it clear that looking at whether or not agreement was reached, it's an objective test. What was objectively could be seen to be agreed here. So parties can conclude a contract, even though a formal document recording the terms has still got to be executed. And whether parties intend to be bound now or later, it depends on an objective appraisal of words and conduct. So with this in mind, what did the court decide here in this case? Well, the court decided that objectively, the 3rd of June correspondence led to a binding legal contract in itself. That exchange of letters was the contract. The letter was a binding offer of settlement. Sun Microsystems offered to settle for a particular sum on certain terms which then Mr Newbery accepted. It's quite clear. The parties intended to create legal relations at that point, and all the terms that were essential to form the contract were agreed. The offer and acceptance was to be recorded, this is the important word, recorded in a suitably worded agreement, which reflected the terms of the contract that they'd just reached. This was not a condition of the creation of the binding agreement. It was an expression of the parties' wishes for a formal record of what had been agreed. It's quite specific on that point. And the reasons for the decision were that the letter did form an offer of settlement, and it was an offer capable of acceptance. It said they were willing to settle the dispute for the amount, they were going to pay in 14 days, the offer was open for acceptance in a certain time. The important wording in that exchange of letters was they said that such settlement, such is an important word there, such settlement to be recorded in a suitably worded agreement. It was not in terms still to be negotiated. So they made their offer and said that the terms that would be recorded of such agreement would be recorded. They did not state on their letter that it was subject to contract. They made no such qualification. So on that basis, the court decided that Mr Newbery was entitled to his compensation. And they made a few points actually about subsequent conduct, which always comes up in these cases, doesn't it? You try and argue a case and say, well, we didn't actually mean it because X, Y and Z followed on, and quite clearly from the subsequent actions we didn't mean to be bound in the first place. And basically the court said that basically where the contract is contained in documents, conduct occurring after the date of the documents, after that date, is not legitimate. There was a contract, and therefore the discussions they had subsequently were not legitimate in determining whether the documents intended to give rise to a legally binding contract. So you couldn't use these discussions that followed on to say, oh, but wait a minute, we didn't actually reach agreement at all, that was a mistake, we didn't do that. Once the parties agreed to the same terms on the same subject matter, by offer and acceptance, the contract is basically, that's it, the contract is formed. You can't go back and argue otherwise. So, I mean, I think there's a couple of points here to bear in mind, and I'm sure you've all got your own ways of making sure you don't end up inadvertently in this position yourselves. You have to basically be aware of what's in front of you. And if you want to enter into a binding contract and you have an offer, you accept it unequivocally, as Mr Newbery clearly did. He accepted the offer. The offer was there. He didn't go back with any qualifications. He accepted the offer. Basically, if you send in a binding offer, you should make sure you put into your offer when it expires. And basically, you should have your consideration, of course. And I think from our clients, people tend to, these days, start the work, the conduct. They start the work before they've agreed the contract. But make sure that basically you're clear in your own mind as to what, particularly in formal communications, is going to amount to a contract. Because perhaps not sufficient care was taken here by Sun Microsystems if it didn't intend to be bound by that letter. And basically, lastly, prevent a contract from being formed inadvertently. Obviously, you can use subject to contract. You can make sure that you're not sending out an offer. You send basically some information to your potential customer. They make an offer to buy, you offer to sell, that kind of thing. You don't end up in a position in a corner, really, that you didn't mean to. Don't send out contracts which you've signed, expecting the other party to sign them. Keep in control of the process. So the point is, I'm using heads of terms. We all use heads of terms. I think what this case shows is be careful with the wording in the heads of terms, because obviously heads of terms can be misleading. Some parts of that could be binding, not binding. I think the whole thing this case illustrates is being clear as to when the contract is formed at all times and making sure everything that you're doing backs that up. And that is a short story about Mr Newbery. Thank you.
Yeah, would it be possible to have those words that you read out relating to the correspondence?
Yes, I'd be happy to make that available. Yeah, I could put it into, make it available to you, yes. Thank you.
Good morning, everyone. I'm going to spend the next 15 to 20 minutes to talk to you about use of the term affiliates in a contract. Now, you're all aware that the term affiliates is quite frequently used in various provisions of a contract. Its use mainly can be to secure rights for an affiliate or to secure rights from an affiliate. Yet, we often find that the use of the term affiliate in a contract can have an adverse effect. And the aim of this talk today is to illustrate through examples the effect the term affiliate could have on various provisions in a contract. Now, we're going to start off by just going through what I consider a standard definition of the term affiliate, and then we're going to look at the use of this definition in some scenarios, mainly in the context of securing rights for affiliates and securing rights from affiliates. I then plan to just highlight to you some of the issues that we come across when this sort of defined term or this term is used, and we'll talk a bit about some possible ways of addressing these issues. Okay, so here we have a sample definition of affiliates, and let's have a quick look at it. It is an entity that directly or indirectly controls. So if you look, I don't know if the mouse, you can see the mouse. So here, company X, where it is directly or indirectly controlling another entity, is controlled directly or indirectly, or is under common control with another entity. These are all affiliates simply because here company X, let's say, is a company of interest. The definition is capturing subsidiaries, both direct and indirect subsidiaries. It is also capturing parent companies and holding companies and any direct and indirect subsidiaries of the parent company. The other term which is used in this definition is control. Well, what does control mean? How does one entity control another? Generally, control of a company is understood to mean if the company in question holds a majority of voting rights. So 50-50 JVs, for example, would not be part of this definition or would not be captured because then there is no control. Another way possibly of controlling an entity and therefore being an affiliate is the ability to directly or indirectly control the management. You know, appoint or remove senior executive members or board teams, or just being able to control the business in some way. So now that we've looked at a sample definition, let's look at examples where this term is used in the contract. Now, as I explained to you, the term is usually used either to secure rights for an affiliate. Classic example is the license, where you as a licensee may want to also have your affiliate be granted the license that you are benefiting from, or secure rights from an affiliate. For example, again, as a licensee, you may wish not only to get rights to the intellectual property rights of your licensor, but also those of its affiliates. So for the party receiving the benefit, the preference or the inclination would be to have a very broad definition of affiliate. Equally, the party providing the benefit would obviously want a very narrow definition. Now, this can be quite a tricky scenario where you may have a situation such as a cross-license, where both parties are providing benefit, but at the same time receiving benefit. And if you both have affiliates, a tricky balance needs to be struck. Let's look at our first example then, where we're trying to secure a right for the affiliate. Classic example is where the licensee seeks a license also for its affiliates. So the term here says licensor grants licensee and its affiliates a license to the licensor's software. Let's just cast our minds back to the definition of affiliate, which I showed to you in the beginning. I haven't written the whole definition out, but just highlighted some of the key bits, which is an entity that directly or indirectly controls, is controlled by, or is under common control. The question is, does this definition work? One of the things we often ask, well, when is this control envisaged? Is this definition meaning to say that it's only those affiliates that exist at the date of the agreement, or is it also capturing future affiliates? And this is often ambiguous in contracts, and more often than not, an analysis is required. The other thing to remember is that this is just one example. It is more than likely that in an agreement of this nature, the term affiliate will also be used in other provisions of the same agreement. So in order to assess whether future affiliates were intended to be captured, one would need to look at where the term was used in different parts of the agreement. And then one would need to consider whether a hypothetical reasonable person would think that the parties did in fact intend to include future affiliates. Now this sounds very straightforward, but it can be quite a tricky exercise because there may be some provisions in the agreement where it would make commercial business sense to include future affiliates. But then there may be other provisions where it does not make sense at all. So that's where some ambiguity arises. And then the next question to ask is, well, if it does cover future affiliates, what does that mean, especially for the licensee? Any company joining the licensees group would, by virtue of such a broad definition, automatically get a license. Now, if you were the licensor, this would be rather inconvenient for you. For example, if you were in the business of generating revenue from licensing, you had this piece of software where every time you licensed the software, you generated some revenue. So if there's a situation where a small licensee of yours suddenly gets acquired or becomes part of a bigger multinational group of companies, by virtue of this definition, which captures future affiliates, that new acquirer or that multinational company automatically has got a license. So that is something to watch out for. Another thing which could happen is that by having the definition such that it captures future affiliates, you may inadvertently grant a license to a competitor. And I have experienced in the past the situation where a company has bought a smaller company who was a licensee simply to get the license and nothing more.
Could that not be prevented by a change of control?
Yes, of course they can. Then you have to think about other provisions in the agreement. But here we're just talking about just the grant provision. And yes, if there wasn't a change of control provision addressing this sort of situation, you would have just this to rely on. So what can you do? I think the simplest thing to do is think more about the defined term and make it clear what your intention is. Are you intending that the affiliates are those that exist as of the effective date, or you are considering not only those that exist at the effective date, but also any future affiliates? Have that discussion, see where this term is used, and try and work out what works for you. And of course, if you're a licensor, your perspective will be quite different than if you were a licensee. The other thing to think about is, well, you've got this license, or the benefit has been given to an affiliate. How long should this benefit last? What happens if one of these affiliates leaves the group of the companies? Does the benefit of the license stop? Well, arguably, yes, it should stop, because if it falls out of the defined term affiliate, it should arguably not then be entitled to the license. But the safest thing is to be specific. So make sure that you also include the words, or it is preferable, maybe not make sure, that's a bit too harsh, but just think about whether the language, so long as such control exists, might be useful to use in your defined term affiliate. And that makes it absolutely clear that once that company leaves, once one of the entities is no longer in the control or forms part of that definition, that's it, it's out of the defined term, and therefore it cannot benefit, in our case, from the license. Now let's move on to look at a second example. In this case, we're talking about securing rights. So we just talked about securing rights for an affiliate. Now we're going to turn it the other way around and secure rights from an affiliate. Now this doesn't happen that often, but it's certainly worth drawing to your attention, because when it happens, these sort of examples sort of give you an idea of where things can go wrong. And one of it is when a licensor grants the licensee a license to use the future intellectual property rights, not only of the licensor, but also those of his affiliates. And you do sometimes see these in situations where there's a very small startup company and maybe another smaller affiliate of that company, where a licensor, a licensee might say, well, yes, I like your technology, but I'm concerned that your affiliate may develop the rest of the technology and I may not get access to it. So not only do I need a license from you, I also need a license to any future intellectual property rights your affiliate develops. Let's go back to the definition. Again, if you have what I call the sample definition, where it just says entity that directly or indirectly controls, where it is not clear if you're capturing a future affiliate. If you are capturing a future affiliate, what happens if this small spin-out or this small company is then acquired by a multinational company? Is it the case that all the intellectual property that this larger company has suddenly gets swept across into this license? Arguably, yes. So this is something you need to be very mindful of, because especially if you are a large multinational company and you're looking to acquire somebody, it is worth looking in, if they have licenses granted out, what the scope of their license is, because this could be potentially a poison pill for an acquirer, and something which we not often see, but we have seen during due diligence. So how do you address this sort of situation? One way would be to say, okay, well, I'll give you a license for any future intellectual property rights of my affiliates, but exclude specifically from the provision any future acquirer and any affiliates of that future acquirer, so that you don't have that situation where the intellectual property rights of the future acquirer just get swept into this license, which the licensor can benefit from. The other thing is simply to limit the future intellectual property rights only to the existing subsidiaries, i.e. the affiliates that exist as of the effective date. A third example by way of which people look to extend the benefit, let's say again of a license, a patent license, a copyright license, to their affiliates, is they include the affiliate as a party to the agreement. And this is one of my pet hates, I have to say, where you see the intention is, well, if I, licensee, want a license, I also want my affiliates to benefit from the license. So the simplest way of doing it is just make sure that the rest of the affiliates are also party to the agreement. So you kind of end up in a situation like this. If you can see the dog with the green collar, I don't know, right here. So that's party, and that's company X's affiliates. So they're all arguably, supposedly, party to the agreement. The question is, are they really all party to the agreement? And I honestly don't know the answers to some of these questions. I'm just posing them in front of you because it's something, the sort of thing which comes up when you're looking at a situation like this. So if you have company X and its affiliates on one side and company Y, but the agreement has just been signed by an authorized signatory of company X, which is, I don't know, UK limited company, whereas the rest of the affiliates are Inc. or based in Germany, does the individual signing for company X even have authority to sign for all these other affiliates and also bind them to the agreement? Probably not. Well, if they don't, then these other parties to the agreement are unlikely to be benefiting from the license which was granted under this agreement. Another thing to think about, if one of these affiliates is in breach, can company Y sue the affiliates directly? Does it have to sue company X, or can it sue the party that's in breach? Is each affiliate of company X responsible for carrying out all the obligations? So, you know, if you have a situation where the licensee is required to undertake some due diligence, you know, fulfill some milestones, does it mean that it's not only company X that has to do it? All the other affiliates in some way also have a role, and do they carry out some of the obligations, or do they have to carry out all the obligations? Also, if company Y is in breach of the contract, is it liable for each, not just company X, but any loss or damage suffered by all the other affiliates? And finally, if, let's say, company X didn't have authority, or the individual signing, to sign for company X, what does this mean for the remaining affiliates? Are they third-party beneficiaries? So the question to think about is, or to consider, is why do you see this quite regularly when affiliates are included as parties to the agreement? really simply it is to extend the rights received by one party to its affiliates. So if that is why you would like or you are considering including the affiliates as party to the agreement, there are alternatives. So let's go back to the licensing scenario where we talked about securing the benefit of a license for your affiliates. If that is the intention, if that's why there has been consideration about including the affiliate as party to the agreement, just consider including the affiliates in the license grant. Or if that's not possible, for some reason the licensor is not willing to do that, there may be another way. You include a right or you negotiate a right to assign the license and or your agreement to the affiliate, or simply just include a right to sublicense the license to your affiliate. And another place where you often see the affiliates as party to the contract is in the context of confidentiality provisions, because you do have companies all over the world, and it is quite often that information is passed between affiliate companies, and therefore it's thought appropriate just to list all the companies as affiliates. What can you do in that situation? Another possible way of dealing with this is simply to have provisions, which you do pretty much in standard CDAs, is allow the parties to disclose to their affiliates, where you have permitted use provisions. If you as a receiving party are receiving confidential information from the other side and you wish to disclose it to your affiliates, ensure that there are provisions in the agreement allowing you to disclose to the affiliates. And also, if this is happening to you and you are the disclosing party, you would be wise including an obligation on the party disclosing to its affiliates to procure that they comply with the provisions of the confidentiality, all the standard provisions of keeping the confidential information secure and secret. A third alternative, rather than include all the affiliates as parties to the agreement, is to make them third-party beneficiaries. And this is something we see quite a lot with respect to indemnity provisions. You often see where Company X indemnifies Company Y and or its affiliates. So in that situation, how would all the affiliates benefit from that indemnity? Well, let's say they are relying on the indemnity and Company X doesn't play ball, refuses to indemnify them. In some situations, then the affiliates of Company Y should be able to enforce the indemnity provision. I just thought I'd draw to your attention the Contract Rights of Third Party Act, which of course is not that recent anymore, but its intention really was to grant some third parties a right to enforce the terms of the contract. And here when I talk about beneficiaries, I mean the ability for the affiliate to enforce a term of the contract, because usually, it can only be the parties to the contract that can enforce the term. And what we tend to see in most agreements is that this act is specifically excluded because you really don't want any party other than the contracting parties enforcing the terms. But an exception can be made. You can consider an exception for the purpose of affiliates if they are benefiting from a certain provision in the contract to give them the ability to actually enforce that term of the contract. And as I said, the most common example is that of the indemnity clause. So that's all that I have, just a few take-home messages. Take care when defining the term affiliate. It is possible that one definition may not fit all the envisaged uses. For example, where we saw that there was a need to exclude future acquirers and their affiliates. Don't purport to include affiliates as parties to the agreement. If your only intention is to secure some rights for the affiliates, there are other ways and means of doing so. Take care not to bind future purchases, especially if you're from a small company and you're granting a license. Do make sure that what you grant doesn't mean that anyone purchasing you in the future ends up having to grant a license to its intellectual property rights. That will be very unpalatable, probably stop the deal happening through anyway. And also consider making your affiliate a beneficiary. That would be a way for them to be able to enforce certain provisions of the agreement under which they themselves are gaining benefit. Okay? Yes?
Can I just check on the definition of affiliates?
Yes.
Let's just say you've got a company A, and you've got another company B, both of which have their own separate structures. So each of them has holding companies and subsidiaries, and at the top has a parent company.
Yeah.
So you've got parent company 1, which is the parent company in its structure of company A, and then you've got parent company 2, which is the parent company of company B.
Yes.
So let's just say you've got one individual shareholder in parent company 1, and you've got that same individual shareholder as the shareholder of parent company 2. Does that mean that companies A and B become affiliates?
No.
By virtue of the fact that there's an individual that
Yes.
stop. You have to have an ultimate legal
There
entity in common.
are definitions that one can use from different pieces of tax legislation which talk about where you've got sister companies, effectively where you've got shared shareholders. But the way that the definitions are structured and the way that they are interpreted is very much looking at corporate structure rather than going behind the corporate groups to who are the shareholders. But that level of connection can be achieved if that's what you're concerned about. And sometimes you do get groups where who the shareholders are really matters, and then you have to look at more sort of sophisticated and bespoke definitions, which are seeking to capture stuff going on behind the scenes.
So that definition would then have to be carefully drafted rather than relying on
Yeah.
statute.
Absolutely.
I would tend to think if that individual held 70% of company 1 and 70% of company 2, I would think in most definitions they would be linked because there's the same ultimate control. They are all under common control of an entity that has the majority holding. I think where it gets complicated is where you've got a group of shareholders and they, the same group of shareholders have shares in both company 1 and company 2, and then that becomes a bit more, because no individual holds a majority, and if they're not, they're independent shareholders, then you could have the situation where effectively they are under common control, but that doesn't fit in with the way the definitions work. So yeah, I think you can get complexities like that.
So I've got a question as well. As you're probably aware, we've recently acquired a privately held company, so none of its agreements included affiliates. My initial concern was over, well, they've become an affiliate of our
Yeah, yeah.
and I think any disclosure of their information is covered by the words affiliates in our confidentiality agreements that we have with other parties. It doesn't work the other way, does it? Are they able to disclose any of our confidential information because the word affiliates doesn't apply?
It all depends on the future CDAs, which
the old CDAs.
under the old CDAs.
Future ones include the words affiliates, but not the old ones.
Can
so
they
we
just
have to go through all of their CDAs and change them to a more up-to-date CDA that includes affiliates?
So in their case, they are the only disclosing party. I mean, arguably you could say that if Victoria's information is being provided through this acquirer, and it is clearly labelled to be confidential information, and they say to them that what we're disclosing to you is our confidential, as in us German entity, it shouldn't matter because they made it pretty clear to the receiving party that it's confidential information, even though it may be, maybe Victoria's confidential.
It would have to be made clear rather than being implied.
Yes, that would be the most pragmatic way of dealing with it. But then going forwards, we sort of make sure that any information that they are disclosing is not just information of their themselves, but also any of their affiliates. Okay? Ask.
Thank you, Sarah. So my name's Osman. I'm going to give you a whirlwind tour of what's new in the world of technology licensing from a competitional perspective. And I'm only going to focus on what's changed rather than go through a step-by-step analysis of technology transfer agreements in the time available. before I do that, I just wanted to take a step back and get you all in the mood to think about technology licensing by reminding you of what the Technology Transfer Block Exemption, or the TTBE as we affectionately call it, is all about. No doubt you'll recall that competition law has a very broad prohibition on any agreement or restriction within an agreement which has as its object or effect the prevention, restriction or distortion of competition. Now that's very broad, so it's a relief to hear that there's the possibility that certain agreements or restrictions can be exempted. Now for common categories of agreement, the European Commission, the European Authority, has issued block exemptions and guidelines which provide legal certainty for businesses. And they do that in a number of ways. They tell you which kinds of provisions almost definitely will give rise to competition or concerns, referred to as hardcore restrictions of competition. They also tell you which kinds of provisions may give rise to concern and need to be looked at a little bit more carefully, and we refer to those as excluded restrictions. It's also important to remember by implication that if they don't comment on a type of restriction, that by implication it ought not to be problematic if the other conditions of the block exemption are met. And importantly, and this is often overlooked, they, as well as giving you guidance on how to assess certain types of restrictions and certain types of agreements, they also tell you how to carry out an individual assessment. So just because an agreement or a particular restriction you have before you doesn't fit neatly within block exemption, don't forget that in principle any agreement or any restriction within an agreement can be individually exempted if on balance it leads to pro rather than anti-competitive effects. So with that in mind, that brings me to the technology transfer block exemption. Now for the licensing of patents, know-how and software copyrights, this is the place to go to get guidance and legal certainty on competition law, the TTB and the accompanying guidelines. And as Matthew's already mentioned, earlier this year a new technology licensing regime, so a new set of a new block exemption and guidelines came into force earlier this year. It's worth noting that the old regime, which was in force in 2004, will continue to apply to agreements which are compliant with that block exemption up until transitional period, which ends in April 2015. So what I've tried to do on this slide is just to think about how I would approach a competition law analysis of a technology transfer agreement. And what I've tried to do is just flag what has changed. So beginning with scope, you'll see that there's nothing next to that, and the regime will continue to cover bilateral licensing of technology for purposes of manufacture. And so, as I've mentioned, that's patents, know-how and software licenses. Other types of IP, such as trademarks, aren't covered by this regime. The same market share thresholds will continue to apply, so if the parties are deemed to be competing parties, there's a market share threshold of 20%. If they're deemed to be non-competing parties, there's a more generous threshold of 30%, and that's in relation to both technology and the product market. So the familiar categories of hardcore restrictions and excluded restrictions are also retained. You'll see that I flagged there that there has been some change in relation to the treatment of passive sales in relation to hardcore restrictions, but that's not something I'm going to touch upon. And just to mention, I have given you slides on all of the changes, although I'm only going to focus on the ones that I've highlighted in red in the time available. So the key changes I'm going to focus on actually relate to this category of excluded restrictions. So these are restrictions where, if they're included in an agreement, they don't benefit from the block exemption, but their inclusion doesn't jeopardize the rest of the agreement, the ability of the rest of the agreement to benefit from block exemption. It's just that these particular provisions you have to look at more carefully, and there have been relatively small but significant changes to the treatment of grant-back provisions and also no challenge provisions, and I'm going to come on to those immediately after this slide. I also just wanted to flag at this stage that there's also further guidance given in the guidelines, which is new. I will talk about the treatment of settlement agreements. There's also some further guidance on how you assess whether a party is competing or not competing, which has repercussions for the entire competition law analysis. I won't go into that today. And also there's some further guidance on multilateral licensing through technology pools, which again isn't something I'm going to cover in the time available. So I'm not talking through all of the slides that you have in your pack. So just skipping this slide on passive sales, I'm going to begin by focusing in on grant-back provisions. Now, if you license out your technology, one of your concerns as a licensor will be to have access to any improvements. And in this context, when I refer to exclusive grant-back provisions, what I mean is provisions give licensors the exclusive right to exploit any improvements under the licensed technology. So that means that the licensee cannot exploit the improvement itself, and it cannot license it out to third parties. Now, previously, exclusive grant-backs of non-severable improvements were block exempted, so they fell within the safe harbour, whereas those for severable improvements didn't. And by non-severable here I mean that those improvements which cannot be exploited without infringing the underlying IP right were considered to be non-severable. But I'm not going to dwell too much on that because that distinction has actually been done away with. And this is a change, especially if you're recycling templates which were created in the old regime. You may see that distinction between severable and non-severable, and that actually has fallen away, so you might want to just revisit that language. And that's because now the block exemption for all exclusive grant-back provisions, whether relating to severable or non-severable, has been removed. So that basically means, it doesn't necessarily mean that those provisions are automatically problematic. It just means that the legal certainty that you had of being within the safe harbour has fallen away, and you have to look at those exclusive grant-back provisions in further detail to individually assess them, see whether on balance they're pro rather than anti-competitive. It's worth flagging that non-exclusive grant-back clauses will continue to benefit from the block exemption. So that, of course, is one option if you favour legal certainty, is to convert those grant-back provisions to being non-exclusive, thereby allowing the licensee to either exploit the improvement itself or license it out to third parties. So what does this all mean? Beginning by thinking about licensors. So it clearly might have a knock-on effect on the willingness of businesses to license out technology. You might prefer to exploit it in-house if having control over that technology is really important to you. But before you think all is doom and gloom as a licensor, I think there are a few points which are worth noting. The first is, which I've already mentioned, is exclusive grant-back obligations might still be individually exempt, albeit with less legal certainty than under the old regime. And I think it's also worth bearing in mind that if you have an exclusive grant-back which is found not to be enforceable, the English courts might be able to salvage part of that clause through the blue pencil test. And it should be possible to draft a license so that the only part of the provision that is void and unenforceable pertains to the exclusivity. So the licensor still retains a non-exclusive license to the improvement. So that's just something worth bearing in mind. And I think a final point to bear in mind is if the improvement is non-severable, licensors might still be able to sue for infringement if their IP is licensed out by the licensee to third parties. So you might still be able to sue the third party for non-severable because your underlying IP will also be infringed. So although the distinction has fallen away, it might still be important in that respect. Now the change is clearly pro-licensee, but for non-severable improvements, again, I think it's important for licensees to remember that they might still face challenges from licensors as a consequence of using their own improvements if you make use of the original licensed technology in a way that you weren't actually licensed under the contract. Or indeed, actually, if you make use of the improvement after the license has expired and thereby you don't have a license to that underlying IP. So just a word of warning for licensees, although broadly speaking, I think it's fair to say that change is pro-licensee. Okay? So, no challenge provision. So when I talk about no challenge clauses, I mean any clause that prevents a licensee from being able to challenge the validity of an IP right. And in this context, when I talk about a terminate on challenge clause, I mean a provision which allows a licensor to terminate a license if the other party does mount a challenge to the underlying IP. So what was the position under the old regime? So no challenge clauses were excluded. So you always had to go away and think about them carefully if they were in your contract as to whether they would be enforceable. But terminate on challenge clauses used to be covered by the block exemption, so you could have some legal certainty that that part of the provision would be enforceable if challenged. So what's the new position? Well, no challenge clauses remain excluded, so the position hasn't changed. There's been position in relation to terminate and challenge clauses has made slightly more complex, and now in order to assess enforceability you have to think about whether the license is exclusive or non-exclusive. So in exclusive licenses, terminate on challenge provisions are still block exempted, so you can still have comfort that that will be enforceable. And the reason given is that licensors might otherwise find themselves locked into an agreement with an exclusive licensee which is no longer making any effort to develop, produce or market the product. And that makes sense. However, terminate on challenge clauses in non-exclusive licenses must now be assessed on an individual basis. So they risk, well, there's a greater chance that they may be found to be unenforceable. So that's in non-exclusive licenses. So thinking a little bit more about what this means for licensees. So clearly licensees in principle have more freedom to challenge the validity of licensed IP with a greater degree of certainty that the underlying IP will continue to be licensed to them until the outcome of that challenge is determined. And indeed this might encourage licensees to start challenging IP, to negotiate lower royalties towards the end of a contract, to kick up a fuss. But a word of warning to licensees who might take that liberty a bit too far, and that's that if you are going to challenge the IP you've been granted, make sure that you fulfilled your obligations under the contract, in particular in relation to royalties. And that's because the guidance tells us that the behaviour of the licensee is going to be an important factor in determining the enforceability of such types of provisions. So you have to be an exemplary licensee, I think, to benefit, or at least to be sure that you can benefit from that change. For licensors, now for licensors exploiting their technology through exclusive arrangements, then there's some comfort that you can be contractually protected from any lock-in with a hostile licensee who's challenging your IP. And this is the reason given indeed in the consultation, was this is particularly important for SMEs whose lifeblood might be licensing out to much larger licensees and whose business may effectively be terminated if that licensee fails to exploit. But it's worth bearing in mind, of course, that those exploiting via non-exclusive arrangements, there's now this strange expectation that you're going to continue as a technology owner to deal with a business or with a party who's challenging your IP rights. And that's an odd position to be in, so it's not a change which hasn't, without controversy. I think it's probably fair to say that overall, again, what you've seen in this, and this is a general theme in terms of the new regime, is that the ability of licensors to protect their IP is somewhat diminished by that tweak to the rules.
In fact, I think it puts non-exclusive licensees in a no-lose situation. So if you take a license of some intellectual property and you're paying royalties on it, and you're a non-exclusive licensee, you could terminate that intellectual property to revoke that intellectual property. You've got nothing to lose. If you succeed in revoking it, then the IP goes away and you don't need to pay royalties. If you fail to revoke it, you get to keep your license anyway. So, as far as the licensee is concerned, what's not to like? Everyone tells you with. It seems a very strange way of balancing the rights.
You may want to think a bit more carefully about the duration of licenses or exclusive licenses.
Yeah.
Because generally, having to have a long-term license, you have to maybe having the right to terminate anyway at a certain point, I think.
And one of the ideas that Matthew and I kicked around a few months ago was also you might want to perhaps even front-load royalties and think about how royalties are spread because of that risk throughout the term of the license as well. Okay? So, of course, most IP disputes never lead to a final determination but are settled, often with the grant of a license to the alleged infringer. And it's generally acknowledged, and it's a relief to hear that the guidelines still acknowledge that it is in the public interest for IP disputes to be settled rather than proceed all the way through costly litigation. But as many of you might be aware, the Commission has become concerned by a certain type of settlement which is mainly found in the pharma sector, and that's so-called pay-for-delay settlements. Now in these, the IP owner might want to avoid a final determination in litigation for a whole host of reasons, and in such circumstances the IP owner might agree to a license, and the licensor might pay the licensee in return for which the licensee might not enter into the market immediately. And so that's sort of broadly, I'll come on to talk about pay-for-delay in a bit more detail. Now, many of you know the Commission had a pharmaceutical sector inquiry which concluded in 2009, and since then it's been monitoring settlement agreements in that sector. And it's also had a number of investigations, sort of the two that spring to mind immediately are Servier and Lundbeck. And to some extent the new guidelines sort of mirror what the Commission's view in those cases is, even though that view hasn't been litigated all the way and approved by the European courts. But maybe just a starting point, the only thing I'm going to cover on this slide is let's just pause a little bit and think about what settlement agreements are in this context. And the guidelines tell us that settlement agreements are agreements which aim to settle genuine disputes or litigation about licensing, and the expression is used is bona fide legal disagreement in relation to technology rights. And again, one of the things that we've been thinking about here is, well, you know, what does bona fide actually mean in this context, and what does there have to be a genuine disagreement about? And at the moment, there's no real guidance on that. So that's going to be something that we find out about as the cases emerge. I'm not going to cover the second bullet point, but I did just want to mention at the bottom there that it's worth reiterating that not every settlement of IP has to be looked through the lens of the Commission's technology transfer regime. It's only when the settlement results in the grant of a relevant IP right does it fall within the guidelines. So, thinking a little bit more about pay-for-delay, and again this is really just an overview. I've just mentioned the first point. There has to be a license of the disputed IP right for you to fall under this regime. And second, it's clear that there has to be a payment or some form of significant value transfer. So we're not just talking about necessarily cash payments here, but any kind of value transfer from the licensor to the licensee. And we assume this means beyond the grant of the license itself. But again, there's a little bit of ambiguity there, and we won't know for some time exactly what is meant by that. The third thing there is that the value transfer, in return for this sort of reverse payment or value transfer, there's some form of limitation on the licensee's entry into the market. Now, the most obvious concern, and the concern that's been looked at in the cases, is pay for delay. So there's a clear temporal limitation on the ability of the licensee to enter into the market. But it's worth mentioning that the guidance goes beyond that and also talks about any pay for restriction type of arrangement, where the licensee accepts some other form of limitation on its ability to exploit the technology. So we're not just talking about delay, there could be some other form of restriction, and that would be enough for it to require closer scrutiny under this regime. And the fourth bullet there, I just mentioned that the Commission said this particular concern arises if the licensor and licensee are considered to be actual or potential competitors. I think it's fair to say that, you know, agreements between competitors are always more likely to give rise to concerns, a point of general principle, so that's not too much of a surprise. So I think what the takeaway for this is, I mean, it is quite a complex area, but I think in terms of things to remember, if you do have a value transfer from the licensor to the licensee in the context of a settlement agreement, and there's any implication as part of that settlement on the ability of the licensee to exploit the technology under that license, I think you have to go away and think about this carefully. And that's not just in the pharma sector, because the guidelines, although they may originate from some of the cases there, the guidelines of course apply to every sector. And at some point we can expect to see enforcement beyond the pharma sector. Final point, it's worth mentioning that where you have a settlement of disputes where exclusive territories have been allocated, I think that there's more likely to be competitional concern if you have a settlement, and that's because any settlement is likely to have some form of territorial restrictions included, which falls into what the Commission may perceive to be market allocation or market sharing. So I think inherently, if that's the model that you operate under, there's a little bit more risk there in terms of settlement agreements. The final thing I want to mention, at the heart of any settlement agreement, of course, is a no-challenge clause, otherwise there's very little point in having a settlement. And although, again, the guidelines say, well, that's all very fine in a bona fide settlement, they tell us that you might need to look at no-challenge clauses in the settlement agreement context in further detail in certain circumstances, and I'm just going to touch upon the first two here. First is that no-challenge clauses might be problematic if the licensor knows or could be expected to know that the IP rights didn't meet the criteria for legal protection. I've mentioned AstraZeneca, so those of you in the pharma sector will be aware of another case brought by the Commission quite some time ago now, where similar issues came up. So that's something to bear in mind. If you're aware of some inherent weakness, procedural weakness in your IP right, then you're going to need to look at the no-challenge provision in the settlement agreement in further detail. The second one there is if the licensor induces financially or otherwise the licensee to agree not to challenge the validity of technology rights. So again, the concern here is over some kind of inducement from the licensor to the licensee not to challenge IP. And the reason for that is the Commission, as well as in principle acknowledging that settlements are in the public interest, they also are keen to promote the public policy that invalid IP rights ought not to be shielded and ought to be challenged and removed. That's actually all I was going to say on settlement agreements, and I think I've run just a couple of minutes over. But I just wanted to point you in the direction. I've actually put the links to the new technology transfer block exemption and guidelines there. And also I just wanted to mention that the Competition and EU team has written quite extensively on that, and most of our publications are available on our blog there. Indeed, Matthew and I have written an article which covers some of the points I've written, so please feel free to visit that if you want further information.